The Philippine archipelago is endowed with rich, lush, and verdant rainforests where rare and unique species of flora and fauna may be found. However, surveys revealed that a mere 850,000 hectares of virgin rainforests are left. Public records also revealed that the previous DNR secretaries have granted timber license agreements or TLAs to various corporations to cut the areas of our rainforests for commercial logging purposes. This continued trend of deforestation brought adverse effects, disastrous consequences, serious injury, and irreparable damage to the environment. This is the controversy raised by the petitioners of this case, who are all minors represented by their respective parents. They instituted a taxpayers' class suit and alleged that they are all citizens of the Republic of the Philippines, taxpayers, and entitled to the full benefit, use, and enjoyment of the natural resource treasure that is the country's virgin tropical rain forests. The same was filed for themselves and others who are equally concerned about the preservation of said resource but are so numerous that it is impracticable to bring them all before the court. The minors further asserted that they represent their generation as well as generations yet unborn. They pray that a judgment be rendered ordering to cancel all existing timber license agreements in the country and desist from receiving, accepting, processing, renewing, or approving new timber license agreements. The Secretary of the DNR, however, fails and refuses to cancel the existing TLAs. According to the petitioners, the Secretary of the DNR's refusal to cancel the TLAs is manifestly contrary to the public policy enunciated in the Philippine Environmental Policy. The original defendant, Secretary Factoran Jr., filed a motion to dismiss the complaint based on two grounds. Number one, the plaintiffs have no cause of action against him. And second, the issue raised by the plaintiffs is a political question which properly pertains to the legislative or executive branches of government. The respondent judge issued an order granting the aforementioned motion to dismiss. Thus, the petitioners have the legal standing to institute the present case. The court ruled in the affirmative. The petitioners instituted the present case as a class suit. The original defendant and the present respondents did not take issue with this matter. Nevertheless, the court hereby ruled that the said civil case is indeed a class suit. The subject matter of the complaint is of common and general interest, not just to several, but to all citizens of the Philippines. Consequently, since the parties are so numerous, it becomes impracticable, if not totally impossible, to bring all of them before the court. The court likewise declares that the plaintiffs herein are numerous and representative enough to ensure the full protection of all concerned interests. Hence, all the requisites for the filing of a valid class suit under Section 12, Rule 3 of the revised Rules of Court are present both in the said civil case and in the instant petition, the latter being but an incident to the former. This case, however, has a special and novel element. The petitioners assert that they represent their generation as well as generations yet unborn. The court finds no difficulty in ruling that they can, for themselves, for others of their generation, and for the succeeding generations, file a class suit. Their personality to sue in behalf of the succeeding generations can only be based on the concept of intergenerational responsibility insofar as the right to a balanced and healthful ecology is concerned. Such a right, as hereinafter expounded, considers the rhythm and harmony of nature. Nature means the created world in its entirety. Such rhythm and harmony indispensably include the judicious disposition, utilization, management, renewal, and conservation of the country's forests, mineral, land, waters, fisheries, wildlife, offshore areas, and other natural resources to the end that their exploration, development, and utilization be equitably accessible to the present as well as future generations. Needless to say, every generation has a responsibility to the next to preserve that rhythm and harmony for the full enjoyment of a balanced and healthful ecology. Put a little differently, the minor's assertion of the right to a sound environment constitutes, at the same time, the performance of their obligation to ensure the protection of that right for the generations to come.